Hello and welcome. My name is Rob Stern and I am with the Washington, D.C. law firm of Stern, Kessler, Goldstein Fox. Today I would like to talk about oral arguments before the United States Patent and Trademark Office's new Patent Trial and Appeal Board. This is a very important part of the patent process in the USA. Now, first of all, let's talk about reasons why an oral hearing may be requested by a patent applicant or by a patent owner at the USPTO, or by a challenger under the new proceedings. First of all, there may have been a real mistake made by the patent office that needs to be rectified, and that the examiners did not get it right, or the central reexamination unit did not get it right. In addition, it may be that the record of this decision does not support the decision. In other words, there are clear indications in the record that the decision is wrong. Another basis or reason why oral argument may be warranted is to create a written record for appeal. Prosecution, where there are interviews with the examiner or interviews in the ex parte reexamination process, do not create a written record for appeal. So this is the first time that a written record is created. And in inter-party reexams, this written record could be very important. And last but not least, the client may want this oral argument to get every possible advantage so that they can prevail. And the client's wishes, as we all know, need to be taken very seriously. So once you request an oral hearing before the board, what happens? Well, a hearing date and time is assigned by the PTAB. Our experience in February of 2013 is that it typically takes the board 3 to 8 weeks after the request is made to assign a hearing date. But sometimes the hearing date may be pushed quite a bit out for some reason that we cannot explain. Now, currently, hearings are held at the Patent and Trademark Office's headquarters in Alexandria, Virginia, in the hearing rooms on the 9th floor of their main building, the Madison Building. There are 3 hearing rooms currently at the USPTO in the Madison Building. Hearing rooms A and B are available, and these are hearing rooms that we normally find ourselves in. There is also a hearing room C that has video conferencing facilities that can be used if the hearing is being conducted with attorneys outside of the Washington, D.C. area. Now, hearings in all of these cases are before panels of 3 administrative patent judges, not an individual judge like you would have at the ITC or at the district court. Like the Federal Circuit, for example, one does not know the judges that you will have for your hearing until the day of the hearing. Now, there are several groups of APJs that are hearing cases at the PTO. Currently, there are 27,000 appeals of original prosecution cases pending at the Patent Trial and Appeal Board. And many of the judges are hearing these appeals so as to reduce this incredible backlog. But there's also a special group of judges that are assigned the appeals of the reexaminations, whether they be ex parte reexaminations or many of the inter-party reexaminations that are currently working their way through the system, from the central reexamination unit to the board to the Federal Circuit. And then, of course, there are these new contested proceeding trials under the inter-party review and the contested business methods, and in the future for the post-grant reviews that will be conducted by the new Patent Trial and Appeal Board. Now, one may find scheduling conflicts occur, like I did recently. And I found that with my reexamination appeal, I was able to request a new hearing date, which was granted to me very promptly. And this would also be the case, I believe, for original prosecution hearings. But note, for the new contested proceedings under the inter-party review and the covered business method, there will be no extensions of time, so you're going to need to appear when the court sets your date. So let's talk about the very critical issue of preparation for an oral hearing before the Patent Trial and Appeal Board, and my focus is on the reexamination appeals that I do so frequently. Now remember, for reexamination appeals, particularly for inter-party review, this is the first time you are on the written record orally, because for inter-party review, there has been no substantive communications except for the written record when you were at the CRU or Central Reexamination Unit level. I typically budget 50 hours of my own time as the attorney arguing the case to prepare for such a hearing. I take these hearings extremely seriously. Remember, you are on the record. Anything that you say will be used against your client on appeal, and additionally can be used against you in concurrent litigation in the district courts and in the International Trade Commission proceedings involving the same patent. What do? I reread first all of the key portions of the record. I cannot emphasize that too much. You must have a complete mastery of the key portions of the record. I usually have a senior member of the team that is working on the reexamination with me, and I start meeting with that individual on a regular basis so that he or she and I can identify the key points that we want to make in our oral argument, and most importantly, identify the key points of attack that we are thinking are going to come from the other side. It's very important, I have found, to work throughout this process with your trial counsel, if you have one, and most often your inside counsel. These people's input, criticism, and feedback are essential to make sure that what you're doing at the Patent Trial and Appeal Board is consistent and in sync with what's going on in the courts and in the overall corporate strategy. I am a very strong believer in mooting my oral argument before simulated APJs, before I go before the board. No matter how strong I think my case is, no matter how good I think my arguments are, I have found these moots to be essential. So how many moots do I recommend? Clearly 3 is the minimum, and I oftentimes do 6, spaced over about a 3-day period. And I use different judges at my moots, oftentimes attorneys in my firm who are very experienced with reexamination, but also my trial counsel, my in-house counsel, and others I use for my moots. And I change up my moot teams so that I get different perspectives, and I give myself sufficient time between the moots to take that feedback and incorporate it back into my oral argument strategy and my documentation that I carry up to the podium. Now let's talk about the day of the oral argument. That's a critical day. It's like an athletic event, in my opinion. It's no different than the day of an oral argument before the Federal Circuit. You have to get into the zone and stay there. When you're standing up at the board, first take a deep breath, look at the judges, identify yourself, and first and foremost, speak slowly and construct clear oral argument presentation that they can readily understand. Tone it down in terms of your voice and your word choice. This is not your district court or ITC argument. Make sure you know all the current case law from the Federal Circuit and the Supreme Court on all the key points, and have those citations, pinpoint citations, ready to present to the court along with key quotes, because the case law is very important to them. Also, have a crib sheet that has all of the key citations to the record for the key points that you are going to be making in your oral argument or that you're going to be refuting. And don't go up there with a big notebook and start paging through the notebook and the record trying to find the critical points. That should not happen. You should carry only a few sheets up with you to the podium, and that's all. If you are carrying big notebooks and going back over to your counsel table, you haven't prepared your case. First and foremost, and all judges tell you this, but observe it to the fault. You have an oral argument to make, but first and foremost, you are there to answer the judge's questions fully and completely and succinctly. You're not there to make your oral argument. If you have sufficient time to make your full argument, great. But first and foremost, your job is to answer their questions. And finally, this is the Patent Office. Be very professional. Be old school. This is not an argument before a jury. This is before a group of administrative patent judges at the USPTO. Conduct yourself accordingly, in my experience. Thank you very much, and I hope this has been of help.